woman suffering from abortion drug harm, that is diametrically opposed to why they entered the medical profession. It comes along with emotional harm. Dr. Scott talks about these being heartbreaking situations and some of the most stressful work she's had to deal with, Your Honor.
Well, I understand that, but I'm talking about the injury of having to divert resources to litigate this.
Oh, with respect to the organizational standing?
The alliance.
Absolutely, Your Honor. So we think Havens Realty is on all fours with this case. The best evidence of that, I believe, is the FDA's reply brief. The government resorts to the underlying briefs in the case to say that there was a contract and an economic harm. But this court's case specifically said that the fact that the nature of the harm was, quote, non-economic, did not prevent the court from finding an injury. In Havens, the court looked to two things: whether there was an impairment of the organization's mission, and second, whether there was an expenditure of resources. Both things are satisfied here. If you look at how our organizations have been harmed, they've been forced to divert resources from speaking and advocating for their pro-life mission generally to explaining the dangers of the harm from abortion drugs. One of the primary reasons that that's required is because in 2016, FDA took away the requirement that abortion providers report adverse events.
Well,
aside from
but that would be anyone who is aggressive or vigilant about bringing lawsuits. Just simply by using resources to advocate their position in court, you say now causes an injury. That seems easy to manufacture.
So I don't think that's true in this case, Justice Thomas. I acknowledge that the lower courts have cabined Havens to say where you have sort of prelude to litigation types of activities. In those sorts of cases, those resource justifications don't count. In this case, if you look at respondents' declarations, they note that they have performed studies, they've analyzed studies. Several of those are in the record, and they're not short. They comb through Medicaid data, they comb through FAERS data to get at the true nature of adverse events. And all those sorts of things are neither a prelude to litigation, nor would they have occurred but for FDA's unlawful conduct in this case.
Counsel, in the line you quoted about economic harm, that had to do with the fact that they didn't intend, through their testers, to rent an apartment. And so there was no economic loss to them or gain to them from renting the apartment. But what I think the SG is pointing to is that they provided services on their own. It wasn't just the members' services that they were relying upon. They were providing services to people to help them rent apartments. And so that's a very important distinction from here, separate from the individual defendants' claims of standing based on wasted resources, their resources. The organizations are not losing anything. So their job is to do exactly what you're talking about, and they're doing it. They're investigating certain problems, but that's not an injury that's redressable by this, by vacating this rule.
So a couple of things, Your Honor. This court's opinion in Havens did not rely on the economic nature at all. Again, I'd point, Your Honor, to the line in Havens where the court says the non-economic nature of respondents' interest in housing. They were speaking broadly. Again, you have to dig to the underlying briefs to find that economic interest that this court did not rely on. With respect to our own injury, it's absolutely redressable. For example, if the regulations are put back in place, the protections whereby individual abortion providers need to provide information about adverse events, that would provide our respondent organizations with more accurate information about the harms from abortion drugs.
Counsel, can I ask you about the remedy and sort of the way that I was talking with the SG? I mean, it makes perfect sense for the individual doctors to seek an exemption, but as I understand it, they already have that. And so what they're asking for here is that in order to prevent them from possibly ever having to do these kinds of procedures, everyone else should be prevented from getting access to this medication. So why isn't that plainly overbroad scope of the remedy the end of this case?
So with respect to the premise of that question, Justice Jackson, I don't think our doctors necessarily are able to object for two reasons. One of this is the emergency nature of these procedures. As the FDA acknowledges, many women do go to the emergency room. And if we just think about what that might look like, take Dr. Francis. She's on the labor and delivery floor supervising.
I'm sorry, I don't want to hypothesize. Tell me in her declaration where she talks about not being able to object or pose a conscientious objection.
She talks about, Your Honor, being I
mean, can you point me to any place in the declarations where a declarant states that they attempted to object but were unable to?
No, Your Honor, for two reasons. One, these are emergency situations. Respondent doctors don't necessarily know until they scrub into that operating room whether this may or may not be abortion drug harm. It could be a miscarriage, it could be an ectopic pregnancy, or it could be an elective abortion, Your Honor. In addition, the government simply cannot get its story straight on EMTALA. If you look at the district court brief in that case, we just heard that the Church Amendment applies. And while we would love for this court to adopt that position, they told the district court the very opposite.
All right, let me ask you this. If we were to find that there are conscientious objections that say hospitals take them into account and these doctors do have a way to not do these kinds of procedures, should we end this case on that basis?
No, Your Honor. We would welcome that holding, but it's not broad enough to remedy our doctors' harm.
Why?
Because these are emergency situations, they can't waste precious moments scrubbing in,
No.
out.
I'm saying assuming we have a world in which they can actually lodge the objections that you say that they have. My question is, isn't that enough to remedy their issue? Do we have to also entertain your argument that no one else in the world can have this drug, or no one else in America should have this drug in order to protect your clients?
So again, Your Honor, it's not possible given the emergency nature of these situations.
Counsel, let me interrupt there. I'm sorry. I think Justice Jackson's saying, let's spot you all that, okay, with respect to your clients. Normally, in Article 3, traditional equitable remedies, we issue, and we say over and over again, provide a remedy sufficient to address the plaintiff's asserted injuries and go no further. We have before us a handful of individuals who have asserted a conscience objection. Normally, we would allow equitable relief to address them. Recently, I think what Justice Jackson's alluding to, we've had, one might call it a rash of universal injunctions or vacatures. And this case seems like a prime example of turning what could be a small lawsuit into a nationwide legislative assembly on an FDA rule or any other federal government action. Thoughts?
Yes, Your Honor. Again, I have to say that I think it's impracticable to raise a conscience objection, but even spotting that, I think the district court remedy here was perfectly appropriate under Section 705. Section 705 grants the reviewing courts the authority to issue all necessary and appropriate relief. And as the government acknowledged in oral argument in Corner Post, when the parties before the court are non-regulated parties, the only avenue in which they can possibly get relief, and of course that's sort of the sine qua non of equitable relief, is that the parties before the court get it. And that's for, as in this case, a state issue, or in other cases, a vacature. And that's because without that sort of relief, the very parties before the court won't get it.
I think why can't the court specify that this relief runs to precisely the parties before the court, as opposed to looking to the agency in general and saying, agency, you can't do this anywhere?
So I think, Your Honor, that might be impracticable. If we're thinking again about the emergency room situation, would Dr. Francis again have to know when she's in the emergency room whether this is a miscarriage, an ectopic pregnancy, or an elective abortion? This is what she does day in and day out. And so it seems like to say that these would run two particular plaintiffs would be missing, that the FDA regulations would still be in place and permit things like mail order abortions. They would have removed the reporting requirements. And if we look at the merits of what FDA did in 2021, FDA relied on two things. They relied first on the FAERS data.
Counsel, before you pivot back to the merits, and I can understand your impulse there. But I went back and looked, and there are exactly 0 universal injunctions that were issued during Franklin Delano Roosevelt's 12 years in office, pretty consequential ones. And over the last 4 years or so, the number is something like 60, and maybe more than that. And they're a relatively new thing. And you're asking us to extend and pursue this relatively new remedial course, which this court has never adopted itself. Lower courts have kind of run with this. And I just want to give you one more shot at that.
Sure, Your Honor. So again, the APA, of course, encapsulates equitable remedies. And as Pomeroy and others have said from the beginning of the 19th century, equity requires that the parties before the court get relief. In this instance, again, as the government pointed out in Corner Post, where you have non-regulated parties, those parties could be farmers, they could be ranchers, they could be the seed farms in Gertsen. But their only availability for relief is if the court does something to the FDA order or regulation at issue. Otherwise, those parties are simply out of luck, and that's inconsistent with equity.
May I ask Ms. Hawley about your basic theory of standing? And just, this is a clarification question as much as it's anything. When you did your 1, 2, 3 in your opening statement, it sounded very probabilistic to me. I mean, I don't remember exactly what the 1, 2, 3 are, but, you know, let's say it's something along the lines of, we represent a lot of doctors, and there are a lot of women out there taking mifepristone, and some fraction of them are going to have adverse events, and some fraction of those are going to come to the emergency room, and so there's some probability or likelihood that one of our doctors who has a conscience objection is going to come face to face with one of these women who has an adverse event. Is that your theory?
No, Your Honor. What we think really shows that respondents have standing here is FDA's own acknowledgments. I would point you to JA 384. And in regulating mifepristone, FDA has continually said that emergency room doctors and OBGYN hospitalists are critical to the safe use of drugs.
Well, I think then it is your theory. I mean, you're just saying even FDA admits that there are going to be some adverse events, people are going to show up in emergency rooms, people are going to come face to face with one of our doctors who objects to some aspect of the treatment. That's the theory, yes?
Well, we certainly think all of that is true, but we don't think it's a problem with probabilistic standing, as was the case under Summers, for 3 reasons. First, Summers involved unidentified members. Here we have 7 named plaintiffs. In addition, and no one in Summers, at least that was still part of the case.
Yeah, so does your theory really depend on your having at least one person? Because I take Summers to be saying, these probability theories, they sound very nice. They have nothing to do with our Article 3 requirements. You need a person. You need a person to be able to come in and meet the court's regular standing requirements. So you agree with that, yes?
I think that's correct, Your Honor, yes.
Okay, so who's your person? I know you have 7 of them, but if you had to pick one and say, go read that declaration, and that declaration is going to tell you why we're entitled to be up here. Who's the person?
So I have to pick 2, Your Honor, but Dr. Francis and Dr. Scott.
Okay, and what about those 2 doctors gives you the kind of imminent injury, let alone the traceability, that we've typically required?
So to speak to Dr. Francis at the beginning, there's been some confusion, I think, about the precise nature of the conscience harm. But if you look at JA 155, paragraph 15, she talks about her and other APLOG members who object not only to taking the life of an unborn child during an elective abortion, but also to, quote, completing that process. That echoes the CMDA declaration at 142 and 143. It's also consistent with—
Has she ever been, because I read that declaration pretty carefully. What actual emergency treatment has she participated in that she objects to and that she has stated an objection to?
So the prior page, Your Honor, JA 154, talks about a D&C, which she was required to perform due to a life-threatening emergency.
She herself performed that.
That is correct, Your
And
Honor.
did she have an opportunity to object? Did she object?
No, Your Honor. Again, these are life-threatening situations in which the choice for a doctor is either to scrub out and try to find someone else, or to treat the woman who's hemorrhaging on the
Usually,
emergency
conscience
table.
objections, the way people with conscience objections do this is they make those objections known. And, you know, that may be harder, it may be easier in a particular context, but most hospitals have mechanisms in place, routines in place to ensure that doctors who are allowed to do this, you know, in advance, right, and are allowed to do it at the moment, they say so. And when I looked at Dr. Francis's and Dr. Scott's, there's just nothing that you have there that suggests, you know, this is like there are, you know, other requirements that you need, but at the very least to be able to say, well, this happened to them in the past, I don't think you have it for either one of those doctors.
So I think we do, Your Honor. Given the emergency nature, it's simply impracticable to have a objection lodged prior to understanding what's going on in that operating room. And again, I'd point, Your Honor, to the District Court Fifth Circuit brief in EMTALA, where the government says that neither the church nor any of the other sponsors of those federal conscience protections intended them to apply in emergency situations. So it's a lot to ask our respondent doctors to go up to the top floor and litigate this with the general counsel when the federal government's telling them they don't have a conscience protection.
Is it true that our standing decisions have not relied on probabilistic determinations like the Department of Commerce case? The court said there was standing because if a question about citizenship was included on the questionnaire, a certain percentage, an unknown percentage of residents would then not fill out the census at all, and therefore it was probable that there was some risk that New York State would risk losing a representative in the House of Representatives or would risk losing money under some federal program, and you put together this chain of probabilities, and that was sufficient to establish standing.
Absolutely. We agree with that, Justice Alito. In particular, you can look at the Gertz Seed Farms case, which also involved non-regulated parties. And this court looked at the distance that bees might fly in order to pollinate seed farms. So it's certainly true that data is appropriate to consider in determining whether there's a substantial risk under SBA list. Here, the FDA admits, this is at 533, that between 2.9 and 4.6% of women will go to the emergency room. It acknowledges, this is at 542, that up to 7% of women will need surgical intervention. And when the FDA talks about there being no increase in adverse events from the increased gestational age, the only way they can say that is by ignoring surgical interventions. And that's because at JA 207, the FDA...
Counsel, what do we do with the fact that these two people that you rely on, Francis and Scope, that Indiana and Texas have abolished abortions and abolished them by pills or otherwise? Now, we can get into whether other people are illegally breaking the law and supplying it contrary to law, but what does that do to your probability? Which is, it's already infinitesimally small because there are thousands of hospitals in the country, 50 states, I don't know how many territories, thousands and thousands of places where pregnant women go who may be suffering from miscarriages or otherwise, to know or to even imagine how one doctor is going to ever actually see a patient that that he or she is going to be forced to intervene on their behalf, but then add to it that this is illegal in these states.
So I think that the best answer, Justice Sotomayor, is that past is prologue. In our declarations, we have 3 doctors who have treated harms from abortion drugs at least a dozen times. We have 2 examples when women went out of state. And if you go out of state, there's a higher likelihood you're not going to have a follow-up visit. What FDA's regime has done is turn ER rooms into those follow-up visits. We've had that happen with both Dr. Jester, where a woman went to New Mexico and returned to Texas, as well as Dr. Johnson, where a woman went to to Illinois and returned to Indiana. Indeed, according to Guttmacher, 1 in 5 abortions take place out of state in surge states like New Mexico, like Illinois, the border states in which our doctors reside.
Ms. Hawley, can I take you back to the affidavits and some of Justice Kagan's questions? You were talking about Dr. Francis. And as I read her allegations, or as her affidavit reads, she said that her partner was forced to perform a D&C when there was a living fetus. And she said she performed a D&C on a woman who was suffering serious complications. But the fact that she performed a D&C does not necessarily mean that there was a living embryo or fetus, because you can have a D&C after, a miscarriage. So if that's right, I mean, I think that the difficulty here is that, at least to me, these affidavits do read more like the conscience objection is strictly to actually participating in the abortion to end the life of the embryo or fetus. And I don't read either Scott or Francis to say that they ever participated in that. So do you want to address that?
Sure. So first, Justice Barrett, I think Dr. Francis's combined with CMDA can be read for the broader conscience harm. Again, that's how the district court understood that. I'd point you to pages 7 and 8. That's how both the state panel and the Fifth Circuit understood respondents' conscience harms to extend beyond simply requiring the ending of an unborn life. And with respect to even the more narrow conscience harm, to whether a doctor may need to end a life, we think there's still a substantial risk of that occurring. If you look at the numbers of the increase from 7 to 10 weeks in gestational age, that means that 3.1% of pregnancies will be ongoing, requiring a D&C. We know at ROA 870 that 55% of those D&Cs occur in the emergency room. This is a substantial number of women suffering abortion drug harm. Again, Guttmacher says 650,000 women took the drug in 2023.
But not all those D&Cs will involve a pregnancy that would otherwise be viable or an embryo or fetus that would otherwise be living, because you can have complications or excessive bleeding even after the abortion is complete in that respect, but there's pregnancy tissue remaining.
So with the 3.1, Your Honor, is ongoing pregnancies.
Is ongoing
yes.
pregnancies.
And FDA says at JA 542 that up to 7% will need surgeries to stop either bleeding or ongoing pregnancies or failures.
How many members of your organization? You have a broad number of doctors that are in your organization. I gather dentists, some doctors who are retired. How many members of your organization are OBGYNs who practice in hospitals who might be called into these ERs?
There are hundreds of them, Your Honor, but I think, may I finish? Sure. I think in particular that the named plaintiffs are OBGYN hospitalists who spend most of their time on the labor and delivery floors, but also are called to the OR to treat these sorts of emergencies.
Ms. Hawley, can you clarify the broader conscience harm from the narrow one? Because I had understood the conscience harm as Justice Barrett does, but you suggest that there's a broader one. So what is that?
Yes, Your Honor. I'd point you to pages 7 and 8 of the district court opinion. And the district court understands the conscience harm to be either taking the life of an unborn child, which would sometimes be required. Dr. Francis testifies to a partner who was required to do that because of emergency situations.
That's what I understood the narrow one to be, right? I'm participating in a procedure that is ending the life.
Yes, I think that's
narrow. Okay, yes. So what's the broader one?
So the broader one, Your Honor, is being complicit in the process that unnecessarily takes an unborn life, such as performing D&C and abortion. And it's really not that hard to see.
No, wait, I'm sorry. Complicit like I work in the emergency room and this is going on. I'm handing them a water bottle. I'm like, what do you mean complicit in the process?
So this court, of course, takes religious beliefs and conscience beliefs
yes.
as it finds
yes.
them. But what harms our doctors, Your Honor, is being involved in completing, in the terms of our declaration, an elective abortion. And it's really not that hard to see why that might be a conscience harm if you think about what's involved in a
But
D&C.
you just said, again, it's being involved in completing an elective abortion. So I took that to be the conscience objection. I think what Justice Jackson is asking, or what I asked before, or what Justice Barrett is there any broader conscience objection that appears, I'm not sure I care all that much about the district court, but that appears in the declarations.
Yes, Your Honor. And in this sense, completing an elective abortion means removing an embryo fetus, whether or not they're alive, as well as placental tissue. Again, Dr. Francis talks about being required to perform a DNC, this is at 154, and remove placental tissue.
Whether or not there's any live tissue.
Yes, Your Honor. And again, this makes sense.
And where are we looking for that?
So I would point, Your Honor, to JA 155, paragraph 15, where again she talks about completing an abortion. The CMDA declaration at pages 142 and 143 also describe this sort of complicity harm from being involved in an elective abortion, Your Honor. And again, these doctors performing a DNC must scrape out a woman's uterus of a child, of the embryo, the fetus, or placental tissue. And this court has recognized harms like that in cases like Little Sisters of the Poor, as well as Hobby Lobby.
No, go ahead.
It's my understanding that sometimes the completion, it doesn't involve surgical intervention. Do you have a sense of how often? I mean, we may get all the way down the chain to the doctor is there, the person is having an emergency procedure. My understanding is with some of these chemical abortion scenarios, the completion occurs by prescribing additional medication. Do you have a sense of how many times the completion is that route and could be done by another physician as opposed to your clients in doing a medical procedure?
So that second dose, Your Honor, of misoprostol has been part of the regimen since 2016, really I think all the way back to 2001, but it's been approved by FDA since 2016. So the best numbers we have from FDA are still consistent with that, and that means that 3.1% of pregnancies at 10 weeks will be ongoing. I'd encourage you to look at JA 405 through 407, and this explains that these risks go up without an in-person visit.
Yeah, no, I guess I'm just trying to get at, I'm still working on how many circumstances or how often it would be that your clients actually have to complete the procedure in the way that you are describing.
So Dr. Scott talks about doing this at least a dozen of times, either a DNC or a suction aspiration abortion to remove, again, embryos, fetuses, or placental tissue. In addition, Your Honor, if you think about the numbers, again, it says 3.1% at 10 weeks, and this has only gone up. In 2020, FDA told this court that the in-person visit was both, quote, necessary and minimally burdensome, and necessary to preserve women's health, precisely so these sorts of situations occur less frequently.
Thank you, counsel. Justice Thomas?
Ms. Hawley, I'm sure you heard the answers of the Solicitor General and the counsel for Danco with respect to the Comstock Act. I'd like you to comment on their answers.
Sure, Justice Thomas. We don't think that there's any case of this court that empowers FDA to ignore other federal law. With respect to the Comstock Act is relevant here. The Comstock Act says that drugs should not be mailed either through the mail or through common carriers. So we think that the plain text of that, Your Honor, is pretty clear.
When did you first raise the Comstock Act?
So I believe the Comstock Act was first raised at the district court, Your Honor, but we think that exhaustion does not apply for two reasons. First, it would be plainly futile as FDA's adoption of the OLC memorandum goes. In addition, this is a whole nother kettle of fish, but if you look at Section 704, exhaustion is only required in two instances, either when required by a statute or by an agency rule when that agency rule is stayed pending litigation. This is consistent with this court's case in Darby. The lower courts have taken conflicting opinions, but we think the better reading of Section 704 is that there's no exhaustion required unless either a statute or agency rule stays the proceeding during judicial review.
Justice Alito? Justice Sotomayor? Justice Kagan?
May I ask about your view of traceability? And, you know, on one understanding, and I want you to tell me if you agree with this, that even beyond proving whatever injury you're trying to prove, that you have to show that that injury is traceable to the 2016 and 2021 FDA actions that you're challenging. And of course, that means showing that these incidents that you're talking about in the emergency room are caused by whatever incremental increase in risk there is as a result of those 2016 and 2021 actions. And I guess my first question is, do you agree with that statement of what you need to show? And if you do, how do you satisfy that? Why do you satisfy that?
So we believe, Justice Kagan, under the case law, that we need to show that each the 2016 action and the 2021 action increased the risk of harm. And we think the way—
But then I guess what I'm saying is that you have to link whatever injury your members have to that increased risk. Do you agree with that?
We do, and we think we can do that for a couple of reasons. First of all, traceability, of course, is de facto. We're not in the Paul's graph sort of world of tort causation. And when you look at the 2021 action, we think traceability is satisfied by FDA's own words. It says at JA 405 that without the in-person visit, this is the Anger study, without that in-person visits, ER and other medical care is likely to increase, as well as surgical interventions. And these are the very same surgical interventions that harm respondent clients.
So there might be some dispute between the two of you as to exactly how big the increased risk is. But let's even take your view that there is, some measurable increased risk. How do you connect that risk to particular actions that your members have, to particular injuries that your members have undergone or imminently will undergo? I mean, it could be, the original risk.
So I think the declarations are actually quite clear on this. If you look at Dr. Francis's declaration, she says that when the in-person visit was enjoined in 2020 by a federal district court, that she saw an increase in emergency room visits from abortion drug harm. Dr. Johnson, Dr. Scott say the same thing. And again, this is entirely consistent with FDA's own numbers. Again, in 2020, FDA told this court that the in-person visit was necessary to preserve women's health because an in-person visit is the best opportunity to examine for things like ectopic pregnancy and accurately assess gestational age.
Thank you.
Justice Gorsuch? Justice Kavanaugh? Justice Barrett?
So General Prelager said that that initial in-person visit had no requirement of an ultrasound or any effort to detect fetal heartbeat. So it wouldn't necessarily give an accurate read on gestational age or detect an ectopic pregnancy. So why would that necessarily, why would the elimination of the visit necessarily increase the risks?
So I think, Your Honor, FDA's own data shows that those risks did go up. If you look at the Caresti study, it shows a nearly threefold increase in emergency room visits when you have the in-person visit and when you removed it. There was 5.8% with an in-person visit, and it was also and about 2.1 without.
Is that because doctors were just kind of voluntarily saying, hey, it would be a good idea to give you an ultrasound or try to detect a fetal heartbeat, or what?
So when FDA removed the in-person visit, Your Honor, it took away the opportunity to do that. I think ACOG, I think medical organizations agree that that is best practice. So if a woman comes into a doctor's office, she's likely to get an ultrasound to accurately assess both ectopic pregnancies, diagnose or assess gestational age. But what's allowed under FDA's rules currently is to be able to order these online with a couple of screening questions, and I don't think that's nearly as good as an in-person exam.
Let me just pivot to the organizational standing question. So let's say that I'm just going to carve out and put aside the costs of filing a petition or litigation as harms to your organization itself. Mm-hmm. Explain to me what additional costs you might have incurred or how your resources were diverted in a way that would satisfy Havens.
Absolutely, Your Honor. So putting to one side the citizen petition, the APLOG declaration is clear that respondent organizations conducted studies and analyzed studies. This included going through the Medicaid data. It included going through the FAERS data to the extent it was available.
Is that it?
Well, those studies, Your Honor, I would point to one of them is at ROA 870, and before and after. And those are pretty comprehensive studies, Your Honor.
And are they to the end of the litigation and the citizen petition, or what are they to the end of?
To accurately assess the harm from abortion drugs, Your Honor. So I think that's absolutely separate from the litigation. And one thing to note with the citizen petition is that is the only way in which anyone can raise a a concern to the FDA. These proceedings go on between Danco and the FDA behind closed doors. This is not a notice and comment process. The first time anyone can raise these objections is a citizen petition.
Justice Jackson?
So what deference, if any, do courts owe the opinion of the expert agency concerning the safety and efficacy of drugs?
So under this court's administrative procedure precedents, Your Honor, APA review, of course, is not toothless. Instead, in this case, we're not asking that the court second-guess the agency determinations at all, but rather look at what FDA said. Again, in 2021, when FDA took away the in-person visit, it did so based on FAERS data. It says elsewhere cannot be used to calculate the incidence of an adverse event, as well as studies that says that JA 407 are, quote, not adequate.
I guess I don't understand how that scope of review is not second-guessing the agency. I mean, they're looking at studies, and you're saying that the court can look at studies, maybe different studies, maybe the same studies, and critique their conclusions about them. So what deference do we owe them at all with respect to their assessment that these studies establish what it is that they say they do about safety and efficacy?
I don't think that's an accurate portrayal of the APA claim at issue here, Your Honor. And the reason being, again, is we're just asking this court to look at what FDA said. The FDCA says you have to have adequate tests and test results, as well as sufficient information.
I understand, but didn't the lower courts go beyond that? I mean, representations were made here today that the lower courts actually relied on studies that have since been found discredited and removed. So they were obviously looking at not just what the FDA was looking at in order to make their assessment. So are you asking us to just look at the FDA and not anything else?
So yes, that claim is not even before this court. But with respect to the two claims that are before the court, the 2016 and the 2021, we think the FDA's own statements here are arbitrary. In 2016, what the FDA said was we're going to look at individual studies, and then even though we say they're interrelated at J298, we're going to take all of the protections away at once. That was arbitrary in State Farm. It would be arbitrary here as well.
Thank you.
Thank you, counsel. Rebuttal, General Prelogar.
Thank you. On associational standing, Mr. Chief Justice, you asked where do you cross the line to get to a certainly impending injury. One thing the court has looked at is whether that harm has materialized in the past and how often. Now, it doesn't always guarantee there will be a future injury, but it can be a source of information. And here, what is so telling is that respondents don't have a specific example of any doctor ever having to violate this care in violation of their conscience. Instead, respondents have pointed to generalized assertions in the declarations that never come out and specifically say by one of their identified members, here's the care I provided, here's how it violated my conscience, and here's why conscience protections were unavailable to me. The fact that they don't have a doctor who's willing to submit that kind of sworn declaration in court, I think demonstrates that the past harm hasn't happened, and the reason for that is because it is so speculative and turns on so many links in the chain that would have to occur, and at the end would be backstopped by having the federal conscience protections in play. On organizational standing, my friend has pointed to the fact that they invested time in preparing their citizen petition. She says they voluntarily conducted studies and then generally refers to diversion of resources. If that is enough, then every organization in this country has standing to challenge any federal policy they dislike. Havens Realty cannot possibly mean that. The court should say so and clarify it is at the outer bounds and respondents don't qualify under that standard. On remedy, Justice Gorsuch, Justice Jackson, you pointed out the striking anomaly here of the nationwide nature of this remedy. Justice Jackson, you suggested maybe a more tailored remedy to the parties protecting their conscience protections should have been entered. The problem here is they sued the FDA. FDA has nothing to do with enforcement of the conscience protections. That's all happening far downstream at the hospital level. And the only way to provide a remedy based on this theory of injury, therefore, was to grant this kind of nationwide relief that is so far removed from FDA's regulatory authority that it's ultimately requiring all women everywhere to change the conditions of use of this drug. And I think it's worth stepping back finally and thinking about the profound mismatch between that theory of injury and the remedy that respondents obtained. They have said that they fear that there might be some emergency room doctor somewhere, someday, who might be presented with some woman who is suffering an incredibly rare complication, and that the doctor might have to provide treatment, notwithstanding the conscience protections. We don't think that harm is materialized, but what the court did to guard against that very remote risk is enter sweeping nationwide relief that restricts access to mifepristone for every single woman in this country, and that causes profound harm. It harms the agency, which had the federal courts come in and displace the agency's scientific judgments. It harms the pharmaceutical industry, which is sounding alarm bells in this case and saying that this would destabilize the system for approving and regulating drugs. And it harms women who need access to medication abortion under the conditions that FDA determined were safe and effective. The court should reverse and remand with instructions to dismiss to conclusively end this litigation.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
and under what circumstances. Each state, regardless of where they stand on this issue, each state has a sovereign interest in deciding that issue for itself and in compliance with the wishes of the people of that state. Abortion is one of those public policy areas that the court has very clearly said resides in the states. Our state legislatures determined that abortion drugs must be dispensed in person, not through mail. They had good reason for doing so. Chemical abortions not only result in far higher percentage of complications resulting in trips to the emergency room, but they also open the door to coerced abortions. Without a physician present, it is far easier for a boyfriend to coerce a woman to take the abortion pill or to slip it into her drink. But regardless, each state is free to make these decisions and assess the risks for itself. That is the essence of the Federalist model that is woven into our Constitution. The Founding Fathers never imagined that the federal government would interfere with the states' rights to regulate abortion, much less that an unelected agency of the federal government would basically sweep aside all of those laws that were so hotly debated in the state legislatures. That is why we states have intervened in this lawsuit. We stand with the physician plaintiffs here, but we also stand in defense of the constitutional authority of each state to decide these policy matters for itself. Thank you.
All right, we'll now take a couple of questions for Aaron.
So there's nothing in the lower court's ruling that would impede access. I think we should all agree that if women decide to use abortion drugs, they should be safe. The FDA's removal of in-person visits removes the best opportunity for a doctor to diagnose ectopic pregnancies or life-threatening conditions. It's simply unsafe to mail drugs to dorm rooms without women having seen a doctor.
Any other questions? All right. Oh.
So the case today was about women's health. Do you think future cases could push the argument further so that the original briefing, all the issues that you raised, including the 2000 approval, which was already illegal, do you think that could be challenged in court following favorable approval for this case?
So the Fifth Circuit found that determination untimely. So what the court is looking at today is, as you said, protections for women's health. So whether these drugs can be mailed across the country without ever having seen a doctor, whether the gestational age can rise even though surgical intervention rates rise along with those gestational ages.
All right, thank you guys so much.
Hi there, I'm Jessica Ellsworth from Hogan Levels. We appreciated the opportunity to present our case to the Supreme Court, and we thank the justices for their thoughtful and thorough questions. The issues in this case are not hard under existing precedent. The same rules should govern here that govern any challenge to any agency decision by any plaintiff. First, the respondents have not been harmed by the FDA's decisions about the use conditions for mifepristone. They fail to show under any rational legal standard why they have standing to bring this suit. The fact is they don't. Second, Congress entrusted the FDA with the sole authority to approve new drugs and subsequent changes. The federal judiciary has respected that authority for decades, applying an appropriately narrow standard of review to FDA's drug approval decisions. In approving mifepristone nearly a quarter of a century ago, and in its subsequent changes to how the use is prescribed and used, the FDA acted on an extensive body of evidence and well within its authority and in accordance with the law. Second-guessing the scientific, data-driven judgments of an independent agency is an extreme position that could inject uncertainty across American life. Under the respondents' theory, the medicines Americans rely on to manage and cure any number of conditions and diseases could be in jeopardy years after FDA's approval. And the ability of the American pharmaceutical industry to develop and get approval for new drugs would be severely harmed, slamming the door on promising research into medicines for everything from Alzheimer's to cancer. Fortunately, there is no basis in law or precedent to find for the respondents, and we have urged the court today to overturn the Fifth Circuit's decision. We thank the court for its time and attention in this matter, and we look forward to its resolution of the case. Thank you.
We won't go back. We won't go back. We won't go back. You heard it from President Johnson. That's stronger than their race. That's stronger than their race. And that's because you say this bullshit. So we want to do this business case on his face. This business case on his face. This